Speaker.
I call the honourable member David Cleandon. Tēnā koe.
Thank you, Mr Speaker. Tēnā koe. Mr Speaker, I'm pleased to speak to this bill to confirm the Greens' continued support for this legislation. It is a necessary piece of legislation. It's practical. It seeks to ensure the integrity and indeed the utility of the primary legislation, the legislation as passed in 2011 or 2012, was it, the final passing. And as the Minister introducing the bill highlighted, the 2011 legislation is intended to make the criminal justice system more transparent, more understandable and more efficient. And those are clearly admirable goals and appropriate goals, and it would be perverse not to support them. It's worth recalling that at the time the legislation was being put through the House in 2011, there were elements of the original drafting that were not admirable and did not win the support of this House, particularly in the proposals to change the practice of trial by jury, to change the practice and policy around the presumption of innocence. And in the event, of course, the Minister at the time lost the majority in the House based around those two critical elements of the original drafting and required him to recant and indeed to redraft the bill into a form that was acceptable, and it ultimately did get passed through the House. Sir, I think the necessity to ensure that our criminal justice system does move speedily and smoothly, that it is streamlined and efficient, has been highlighted recently in the context of conversations around the bail laws and perceived necessity of amendment to those. We have seen reports of increased offending by people on bail, and clearly one of the drivers of that is simply that people are being on bail for much longer than is desirable, and in part that is due to the fact that the courts are not able to put cases through. Hearings are taking too long, the process is slower than it ought to be and that it ideally would be, and anything we can do to amend that has got to be a desirable thing and something we will support. However, there is a disconnect, I have to say, between the intention of this bill, the efficiency, the streamlining of the justice process and of the court process, and other policies, other legislation, other practice of this government, where they seem almost deliberately to be setting out to slow the functioning of the courts, to make the courts less effective, less efficient than they ought and they need to be. And I think of issues like the numbers of court staff. As with elsewhere in the public service, we are seeing a reduction in numbers. We are hearing from lawyers, from people working in the justice sector, that we are seeing a loss of experienced staff in the courts, that as a result of that, we are not seeing the courts operating as effectively, as efficiently as they might. That is clearly not a desirable thing. We should be at least ensuring we have sufficient, well-trained, well-qualified and experienced staff in our courts to ensure the prompt and the effective delivery of justice to people going through the court system. Similarly, it seems perverse at a time when we're seeking to improve the functioning of the court system that we are closing courthouses in some of our provincial areas and reducing services available at other courts. This is not helpful, clearly, to the public, to those who are obliged to engage.
I'm sorry to interrupt the honourable member. The time has come for me to leave the chair. This debate is interrupted and the People's House stands suspended until 9 a.m. when I shall resume the chair. Te hei mōri ora, parakura haramia, hari rā po maruhi. Good evening, honourable members.